I'm sure that's happened today, right?
Yes.
Or at least this week.
I think we're on 2:30.
Yeah, let's party.
Hello, everyone. Welcome to the 8th annual Startup Boston Week. You've made it to the 2:30 session. This is going to be a great one. We're talking about your first financing and the nitty gritty and all the things that go along with it. And we've got two great people on our panel here that have joined us from Foley and Lardner, who we want to thank very much for this session. We're going to be talking about it. And of course, Suffolk University. If you haven't been at Suffolk University, what a great place this is and a perfect part of Boston. And so we've got the next hour or so for you to enjoy and learning all about the first financing round. I'm Puck Fernston. Thank you very much.
Thank
Take
you
it
so
away.
much, Puck. Hi, everyone. Thanks so much for joining us today. I'm Alicia Dorner. I'm a senior counsel at Foley and Lardner, based here in our Boston office. And I'll introduce my colleague in a second here. But just to give you a quick overview of what we're talking about today, as Puck mentioned, we are talking about the nitty gritty of your first financing. So the first time you're going to raise money in a priced round. So we will get into all of the details, and to the extent that anyone has questions, of course, we'll save some time for the end, but feel free to jump right in. Honestly, we would love to add texture to the conversation, and so please feel free to just raise your hand and let us know if you have any questions or thoughts to add into the conversation. So without further ado, I'll give you just a really quick background on Foley and Lardner. So we are a very large law firm. We have 27 offices all across the U.S. and Mexico. We have about 1,200 attorneys. Paige and I represent the transactions practice group, in particular the emerging company and venture capital practice group. So we work a lot with early stage companies doing exactly this kind of thing, helping them get organized and then raise money and eventually do an exit transaction. So we do M&A, and we have specialists across the board. So whether it's intellectual property, labor and employment, litigation, hopefully you never need, but we have everyone sort of soup to nuts for our early stage companies and investors. So should you need anything, please come introduce yourself at the end of this. And in particular, I wanted to mention we have QR codes, 2 up here and 1 at the registration desk, where you can put in your email address and we will reach out to you right after this. So that we can set up time for a complimentary consultation and talk about if you have some legal needs that we can help satisfy for you. So with that, I will jump right into proper introductions. As I mentioned, my name is Alicia Dorner, based here in the Boston office, represent early stage companies, founders, investors, as well as buyers and sellers in the M&A context. And I also do a lot of work on the West Coast. We have a Silicon Valley office who I work closely with. So I'm a bit of a bi-coastal, although geographically here in Boston. And this is my colleague, Paige Moscow, who will tell you a little bit about her background.
Hi, I'm Paige. I'm also an attorney in the Boston office, and my practice is very similar to Alicia's. So probably 50% of my practice is representing emerging companies and VC firms in financing transactions, and the other half of my practice is private equity, mergers and acquisitions, both representing sellers selling to private equity and private equity firms. So spans the gambit from incorporation of a company all the way to sale.
Great. All right. So we want to give you a little bit of a roadmap for the day. If we could do the next slide, please. Thank you so much. Okay, so this is sort of the general outline of how we want to keep this organized for you. As we titled this very intentionally, we're planning to get into the nitty-gritty. So while, of course, there will be an overview, we're going to do a deep dive into the details and sort of highlight for you the details that are the most important when you're going through each section of the process. And so just to give you a high level, first things first, we're going to talk about getting organized, because the thing that can save you time and money in your first financing round is basically having your stuff together, because you will have to do it at some point. So do it when you can and when your back is not up against the wall to get a financing round closed. Then we're going to dive into the term sheet itself. I know there have been some other sessions this week that have been super helpful talking about the term sheet, but we will spend some time talking about the nitty-gritty of the term sheet itself, what to pay close attention to, what to be aware of, and then moving on to the path to closing. How do you actually get the round done? After you have your term sheet signed, everybody's excited, ready to go. What happens next? And last but not least, of course, we'll try to spend some time talking about common pitfalls if time allows. And of course, Q&A. So without further ado, next slide, please. All right, so first things first, get organized. Many of you here, of course, are early stage founders, and you're thinking about, okay, when is the right time to raise? How do I raise? And with whom do I raise? One of the things that we could spend all day talking about those three topics, but in terms of when is the right time to raise and how do I raise specifically, one of the most impactful things that you can truly do for yourself is get yourself organized. And so even if it's just you or you and one co-founder and you think, I don't really need too many bells and whistles, but what can I do so that I'm ready when the time comes, when somebody shows up with a term sheet? How can I be ready for that conversation? So let me first ask my colleague Paige, what are the most important things that a founder can be thinking about to prepare themselves for this process?
Yeah, absolutely. So getting organized might sound simple, right? But it's actually going to be one of the most critical things you can do because before an investor puts money into the company, one of the first things they're going to do is they're going to hire outside counsel like us, and we've been on the other side, to dig into your documents from a legal perspective. And so we're going to talk a little bit more on the next slide about what that specifically looks like. But first, let's talk about some of the more critical things that investors' counsel is going to be looking for when they're looking at your documents. So number one is formation documents. And so this is probably the most simple of what we're going to talk about. So investors' counsel wants to make sure that you have an entity that's properly formed. And also, they're going to want to understand kind of the corporate governance of your entity. So if you're a corporation, they're going to want to understand who's on the board. They're going to want to understand what kind of approvals are necessary for the transaction to occur. And if you're an LLC, are you member managed? Do you have a board of managers? Essentially, what approvals are going to be necessary for the transaction to happen. And so here, it's really just gathering your certificate of incorporation, your bylaws, any internal shareholder agreements that you might have, and then if you're an LLC, certificate of formation and operating agreement. Okay, so you have your formation documents together. Next is capitalization. And so this is really critical. And so you're going to want to make sure that you have a clean and clear capitalization table to provide to the investor. And what this means is, the investor's not just going to be looking at what's on your cap table. They're going to want to be looking at what's behind the numbers. So investors' counsel is going to be asking for documentation backing up, and they're going to do something called tying out the cap table, right? So they're going to want to see your board consents or minutes approving those folks on the cap table. So for example, if you have a cap table with Taylor, who owns 1 million shares of common stock, investors' counsel is going to ask you for a board consent showing approval of those issuances along with potentially some stock purchase documentation. And if they look at those board consents and they see, Travis or Taylor has 1,500,000 shares of common stock instead of 1 million, but Taylor had transferred them to Travis, they're going to want to see documentation showing the transfer. So really, you're going to want to have documentation kind of tying out exactly what's on your cap table. And if you don't have it, that's okay, and that's where your lawyers come in and can help you clean that up before investors' counsel starts digging into that. And just another point to make on the cap table is the investors are going to want to see, are there any kind of rogue folks on the cap table who own like a significant percentage of the company. So if there was a founder, in the beginning who, maybe has 30, 40% of the company and left and is no longer working with the company, that's going to be a red flag. And so, that's another thing that investors are going to be looking for in the cap table. Basically, who's on there, and are they still involved with providing services to the company? So options and 409A valuation. So options are very much tied to the cap table. And so if the company has granted options, those should also be on the cap table. And similar to, straight equity, for options, Investors Council is also going to be looking for board consents approving the options. And this is an area where we see a lot of
Common
issues.
pitfalls.
Yes.
You'll see that on our last
And it's
slide.
very normal. We have this all the time with clients, dealing with clients right now who have granted options, improperly. And so what's really important to remember is for options to be valid, the board needs to approve them. So there needs to be some sort of like resolutions or documentation showing, how many options you're granting to each person, the vesting schedule, exercise price, very clear and laid out. So that's another, yeah, sure, go ahead.
Sorry, what if it was just options that were set aside as a pool, but not yet granted to anyone?
Yeah, so the pool would also, the pool is part of the actual equity incentive plan under which you grant the options. So that equity incentive plan needs to be approved by both the shareholders and the board when it's first adopted. And that's something that Investors Council is going to look at. And in that consent is where you also approve of the pool. So that's also going to be tracked as well. That's a good question.
And I should also mention too, something that we see come up a lot, not necessarily a pitfall, but something to, sort of speak the language, walk the walk when you're talking to these investors is you might have, let's say you've issued yourself 90,000 common shares and you're a sole founder, super simple, super vanilla, and you've thought to yourself, okay, I know I'm going to be bringing on more team members, and so I'm setting aside conceptually 10,000 shares, so it's like 90-10. That's okay, but if you don't actually have an equity plan in place, you don't actually have shares set aside either for that option plan. You will do that as part of your first financing round. Almost every investor will require you physically set those aside using the specific documentation and the board and stockholder approved plan. And that will all be documented in line with your first financing round documents. But before that, if you don't actually have the plan yet, or you don't actually have it set aside in a legal sense, you don't really need to have it on your cap table if it doesn't yet exist, and you certainly haven't granted anything out to people too. Yeah, that's one clarification.
And that brings up a good point, because also when, if you have options on your cap table, Investors Council is going to say, okay, I want to see a copy of your equity incentive plan, because you need to have the plan in order to grant options. So they want to see your equity incentive plan and any amendments, because, if you're going to increase the size of the pool to grant additional options, those would be through amendments to the plan. And they're also going to want to see something called a 409A valuation. And 409A comes from the Internal Revenue Code, Section 409A, which basically speaks to the valuation of private company stock, boiling it down. And so when you grant an option to your employees, the exercise price of the option, which means the price that the optionee is going to have to pay to turn that option into stock, it has to be equal to the fair market value of a share of common stock as of the date of grant. And so in order to determine what that value is, there's something called the 409A valuation, which you may have heard of. And cap table management services like Carda will provide this if you sign up, and there's other valuation services. But when an Investors Council looks at your cap table, they're going to look and make sure that for the exercise price, there's a backup 409A valuation that ties to that exercise price. And typically the valuation will last for a year, unless there's some intervening event like, you raise a round or something like that might change the value. So that's something else that you're going to want to have together if you do have options in place prior to a financing round. And then finally, so intellectual property. So a lot of times the value of your company really stems from your intellectual property, especially if you're an innovative technology company. And so one of the ways that Investors Council is going to look to see if the company actually owns the IP that it says it owns, is it's going to ask for confidential information and invention assignment agreements, or CIIAs. And these are really critical because these basically are what they sound like. So number one, everyone who signs one of these is basically saying, I'm going to keep company information confidential. I'm not going to disclose it to third parties. And critically, anything that I produce in my service to the company belongs to the company. And if you don't have one of these in place, then whatever your service provider, your employee, your founder has produced for the company doesn't belong to the company. And so we always, whenever we're forming a company, each founder and every employee and service provider should be signing one of these documents. And Investors Council is going to ask to see copies of these, especially for those who have contributed significant intellectual property to the company. So we always suggest, as part of an onboarding, if you're going to hire employees, this should be part of the package because it's really important to make sure that your IP is owned by the company and not the individual. Because if they leave, you don't own that IP anymore. So this is really important. Yeah.
So I currently have a company.
Microphone to the rescue.
Thank you. So I currently have a consulting company that has the IP. So when I'm spinning off this new company that's getting ready for fundraising, so I need a document to transfer the IP from the existing company to the new company. Is that the right approach?
Potentially, yeah. Okay. So it depends on exactly the kind of structure that you're going to have. If ultimately the original company, let's call it, that holds the IP currently, if that's going to continue to exist for a different purpose, right, then you'll at least want to set up or need to set up a license agreement between that entity and the entity that will be doing the fundraising. And so it really depends on the specific dynamics of what the business proposition is. If it is IP that is super fundamental to the value proposition that the entity that is fundraising is bringing to the table to investors, it's more likely that they would probably require that it be transferred to the entity they're actually putting the money into.
I see. Okay, thank you.
But sometimes the license agreement works. It really just depends on the situation.
So it's either, depending on the situation,
either a transfer
licensing
or a licensing agreement.
I see. And does it matter if the R&D development so far has been funded by the parent company, the existing company, but now we're spinning off to a separate entity?
Ooh, it's getting juicy. The answer is, you're going to kill me for this. This is the lawyer answer, but it depends. It depends. We can talk afterwards.
Okay, cool.
Great.
Thank you.
Okay, so
one more question, actually.
Oh, yeah.
Hey. Hi. You referenced Carta, and I've used Carta before to avoid a lot of the things you mentioned, but for younger startups, it's not a great use of funds. And so I'm curious, for the clients you've worked with who are maybe pre-Series A or even looking at their first big seed round, are there other platforms that you've seen that work well at avoiding some of these?
There are other platforms, and I'm curious to see if you have a different view on this. There are other platforms. It's going to be a pretty similar outcome when it comes down to how much is it going to cost you to get a 409A, which I assume is what you're referring to specifically. Oh, okay, all of it. So, okay, cap table management is so important. But when we're really talking about the earliest stages, where let's say it's just you and a co-founder, and maybe you come and get some legal help in terms of actually getting the documents in place, right? Of filing the charter, having a very basic, maybe it's bylaws, the fundamental board consents and stockholder consent to issue yourself the founder stock. And you want to do that immediately, by the way. Don't just form the entity. If you're in this stage, don't just form the entity and not issue the founder stock immediately, because if things take off really quickly, which is of course the dream, and all of a sudden that stock is worth more than zero and you did not properly document that you bought your own founder shares when they were zero, then you're going to have a more complicated question for us. But to answer your question, cap table management via Carta or any of the other, Fidelity has a great option, and there's a few others on the market. You don't necessarily need it day one, other than, as Paige mentioned, getting a 409A valuation when you start issuing options is really important. But if you're in those very early pre-seed stages, where essentially you can do it on an Excel spreadsheet, if you're talking about it's you and a co-founder and it's 50-50 or 80-20, whatever the split is, or if you are bringing someone in sort of on the finance side, that they can keep the records. But what's most important really is the record keeping of those board consents, of those stockholder consents, of those grants of common stock, and those can live in a Google Doc drive. They can live in a DocSend. They don't necessarily have to live in Carta, but Carta's and similar products. When I say Carta, I mean all of the cap table management products really have more value for the very early stages, when the cap table gets a little more complicated. When you start issuing those options, or when you bring in advisors and issue them some shares, that's when it starts to make sense for the cost benefit analysis.
Yeah, I was going to say similarly, that usually our very early stage clients just use Excel spreadsheets, and really it's when you start bringing on employees and you have to keep track of all the vesting schedules, and really where it's helpful is when employees are terminated or they start leaving, because then you have to keep track of, okay, when does this option expire? And that's going to be important, right, for the cap table, because it can change, what the fully diluted percentage ownership is. And again, that's going to be important for an investor, right? Because they want to know, I'm putting in $5 million, am I getting 20% of the company? So that's where Carta really helps, when you start having all of these other employees with options and different vesting schedules with, acceleration upon a change of control, and you need to keep track of all of that. But in the beginning, an Excel spreadsheet is sufficient.
Yes, exactly. Find a friend who's really good at Excel, or a lawyer who's very good at Excel, and you'll be in good business until the time comes that Carta or something similar makes more sense. Yes, exactly. AngelList is another good example.
Alicia, just a note to everybody. If you have a question, raise your hand and get the microphone, because we have a lot of people online that want to hear what you have to say, believe it or not. So keep going. And we have a question over here, if we can add that in.
Oh, fantastic, please.
Thank you. In terms of intellectual property, I know there are a couple different forms or agreements rather that are used, like TAA, PIIA. Can a consulting agreement be used in lieu, and can you just include a provision regarding IP protection under the company?
The short answer is yes, you can. You can have consulting agreements that incorporate the meat of those PIIAs, but the language has to be very precise to cover all the bases of what you would have otherwise had in a PIIA. But yes, we do see those two married together, and that's a very efficient way of handling it.
Okay. And in terms of the difference, or can you elaborate a little further on TAAs versus PIIAs? Is it a just purely chronological difference of when
The
people
funny
are-
answer, you're not going to expect this one from
Yeah.
me. There's no difference. You can call it anything you want. Some people call it a confidentiality agreement. Some people call it a PIIA. Some people just call it an IP assignment. And we are talking about the same thing.
Okay.
And so it should be the same thing in a perfect world, right? And that's why you have lawyers look at it and make sure it actually covers all your bases. But in the universe of talking about that sort of subset of contracts, different names for the same thing.
Yeah, the one thing I'll say is it's the one thing that might differ is sometimes you'll see a non-solicit provision.
Yeah.
There used to be non-competes a bit more, but now, the enforceability of non-competes is kind of up in the air depending on the state you're in. So a lot of times we just take it out, but sometimes you'll see a non-solicit, like a 1-year non-solicit provision in the IP assignment agreement, but otherwise, it's the same.
Thank you.
Sure. Any other questions before we move on? Okay. I
Okay.
We're ready
so-
for the next slide then. Oh, I think we're already there. Okay, great. Great. So next thing, I have to thank you for your question about where to store documents because that leads us perfectly into the next topic. So thank you very much. So the next thing that you can do to really set yourself up for success is get together a data room, and a data room does not need to be a really high tech, a name that you've heard out there from somebody who you know who does private equity and uses this particular kind of data room software. It can literally be, and it often is, a Google Drive, often a DocSend, something like that, but something that's very simple, very well organized, and covers the following things. And the list I have here is just kind of an example of what you might see in a diligence request list that would come from an investor. There is no one perfect diligence request list. You can sort of slice and dice these any way you want, but there are certain things on a diligence request list that you would expect to see from basically any investor. And I should also mention here, as we have just, kind of the first page of what a diligence request list might look like, please feel free to reach out to us, and we're happy to share sort of a standard form diligence request list that can help guide you. And, here's a folder structure of like really basic stuff of how to set yourself up for success. We also have on our Foley and Lardner website something called Foley Ignite that has a toolkit for founders. So it's all of the basic documents, basic consulting agreements, basic IP assignment agreements that are basically plug and play for what you might need. And one of the tools that is available on our Foley Ignite toolkit is also a sample diligence request list to help you do exactly this. So think of this as a guide. And when you receive a diligence request list from a potential investor, of course, after you've signed NDAs and you're sort of well on your way to negotiating a potential investment, you may want to sort of reorient your data room, to match their request to make sure you're being responsive. But on the whole, if you have a well thought out data room in advance, they will, number one, be impressed. And number two, it'll save you a lot of time because their lawyers can dive right into it. And so there's not sort of that waiting period of, okay, here's our question list. Okay, we'll get back to you in 3 business days after our lawyers have access to the data room. And you can just sort of hit the ground running, which is good for everyone.
And another good thing you can do is you can use this as the request list as kind of an index. And so that will really impress the investor. And instead of them giving you their list, they'll go look through the data room first and provide supplemental requests.
Right.
So
to give you a highlight of what these topics are, and I'll try to get through this pretty quickly because now we get into the really juicy stuff after this. But diligence request list would cover the really basic things that Paige was talking about in the prior topic, which is your charter documents, your certificate of organization, your bylaws, board and stockholder consents, the very basic corporate governance documents that you should have in place. Your capitalization records is the next big section that you should definitely have. So all of your common stock issuance agreements, whether it's, in the form of a subscription agreement or a founder's agreement or otherwise. Again, another situation where lots of different names to accomplish the same purpose, but as long as we have some agreement that makes clear how many shares were issued, when they were issued, to whom they were issued, it is signed and dated, then, all things being equal, that's going to fit and tick the box in this category, and corresponding board consents. Let's see, financials. So you may be thinking, okay, well, I'm raising my first round. I don't have audited financials. That's okay. You probably have some kind of at least projections or budgets, ideally both, and maybe you have some unaudited financials. But whatever it is that you do have, whatever you're working with at that stage, even if it's very, very little and it's just, hey, I am just starting out and this is my projected budget for the next 12 months, that's what the investor is going to want to see. Legal and regulatory. If for your first financing round, hopefully this is empty. That would be great. Legal and regulatory is really sort of the holding spot for, of course, do you have any litigation or potential litigation? Have you received any sort of nasty grams from someone, right? Did you have a co-founder breakup where when let's say one of the co-founders left under, maybe not so great terms, and there's a nasty gram email saying, well, obviously I own 50% even though I'm leaving. That kind of thing, let's just get it out in the open from the beginning. At least talk to your counsel about it before you open up the data room to investors to see. But put that kind of stuff at least on the table for discussion with your counsel on how to handle from the get-go, because when that comes up in a later phase, it can cause more trouble. And then regulatory, of course, this is very fact-specific to the industry that you're in. But to the extent that what you're doing requires any kind of regulatory oversight, or perhaps you've done an analysis as to why it does it, it should go in this folder. Any kind of permits, anything, licenses, things like that, also similarly should go in this folder. And then moving on to employees and consultants. So very early stage, you may not have any employees or consultants, but if in the event you do, their agreements should all be in writing. Again, on our Fully Ignite toolkit, shameless plug, you can get these for free. So, just some good forms to get you started with. And if you have any questions, of course, you can reach out to us. But that's a good place to get started, to have something, at least, an offer letter for employees if you don't feel like you need a full-blown employment agreement. And then for consultants, make sure that everybody, just to hit this point home again, signs IP assignment agreements or confidentiality agreements that incorporate IP assignment. And then last two categories are just debt. If you've taken out any kind of debt financing, no matter how small, that is something that you should provide the documents for. If you have even a line of credit or a credit card that you've been using for the business specifically, try to document that and put it in a folder, and the investors will appreciate that. Certainly, if you've taken out any business loans and that kind of true lender debt, those documents should go in. And last but not least, the full catch-all of agreements. This could be anything from you have a first customer or you have a pilot agreement. Certainly, they'll want to see that. It can also be vendor agreements. So you need certain supplies to run the early experiments for the research you're doing for your early stage business. All of those should go in the folder. Similarly, sort of last but not least, is if you've signed NDAs or other sort of preliminary agreements with third parties, even though it's not a customer and not a vendor, there's sort of this other category. If you have signed other agreements, just keep track of them and stick them in this folder. And, we can always take them out if they're not relevant, but it's always better from the founder perspective to over-disclose, over-provide, provide everything under the sun. And if you start with sort of good corporate hygiene from the beginning, it will not be a heavy lift down the road. So that is something that will save you time and money, again, down the road. Any questions on diligence request lists and data rooms? Yes, in the back, in the hat.
You mentioned investors and NDAs. A lot of the investors I meet as I'm trying to when I'm fundraising are allergic to NDAs.
Yeah.
When do you insist that they sign one? I'm assuming before the data room is shared, or when
Yeah.
do I need to say, no, I won't say anymore until you sign an NDA?
I love the phrase that you used, allergic to NDAs, because it's funny, in this exact context, that's how the phrase is utilized almost all the time, and I think it's really appropriate. We see that a lot too. So I don't mean to suggest actually that every investor will sign an NDA. Certainly many will not. And the balance here, for anyone who hasn't sort of had those discussions yet, is that the investors might be talking to 1,000 different companies, 200 of which might be in your space or space that is similar to yours. So it's a liability protection, a risk allocation question of, okay, we're having these discussions. I'm sharing with you some level of detail of what I'm building here, and what I'm building is different from anybody else in the marketplace. So I don't want you, investor, to learn how I'm doing what I'm doing without first signing an NDA, so I know you're not going to take my idea and run it over to the next person. The flip side of that, from the investor perspective, is I take 1,000 of these meetings a year, maybe more, And I cannot possibly keep track of, sort of a very preliminary idea that someone shared with me one time, and then maybe somebody else starts talking about that very idea 6 months later, and it seems novel to me at the time, and then I get accused of breaking an NDA. So it's really, really dependent on how much you're sharing. So if what you're building has a true secret sauce and has a true, let's say, for example, it's a scientific component that, here's what I'm planning to get a patent for. Here's my patent application filing, and here's what I'm doing, and this is the secret sauce. Do not share that without an NDA. And also be very careful about who it is you're talking to on the investor side. There's a judgment call to be had, and while it would be great if every investor would sign an NDA, it certainly won't be practical. So I think it's a balance of considering how much detail you're actually sharing with that investor, at what stage in the process, how well do you know this investor, and basically doing the risk analysis for yourself of how comfortable are you if what you are sharing were to be shared with your competitors, for example. So always, this is a little side tip, this is not necessarily germane to this exact topic, but always have at least 2 versions of your pitch deck, right? You want one that has super high level, this is just a teaser, here's who we are, here's what we're doing. And then the next level of detail after that, which is, hey, now that you're interested, here's a little bit that's more interesting about what we're doing and why you should want to invest. But even in that second level, you do not put the full secret sauce in it, because you will probably not want to share that without an NDA, so that's a different level of conversation.
Yeah, and in all cases, before you open a data room to an investor, you need to get an NDA signed. And part of the reason for that is because now you're dealing with other third parties' information a lot of the time. So if you have customer or vendor agreements, there might be confidentiality provisions in those agreements. And so you really need to be careful when now you're opening the data room to information that involves other third parties, that you're protected in that scenario as well. So that's why it's really important before you kind of open the full book that you do have an NDA in place.
Great answers. Alicia, we got a couple of questions online.
Oh, let's do it.
This one's for both of you. Someone's asking about red flags. And if everything on that list isn't done right, 1, is that a red flag? And then 2, say they've done everything right, but then they've got some dead weight. So they've got an employee or a founder that was there that is gone. What do they do about that?
Yes. Okay. So to tackle the first question first of, what if we don't quite have it all together, right? Or, hey, we can upload half of this, but we know we never quite got the board consent signed, or we know we never quite got, the IP assignment signed, for example, super critical since we touched on it a few times. That's why we're suggesting to do this early. Don't wait until you get the diligence request list from the investor, because at that point your back is against the wall in timing to get the round closed. Do it early. Work with your counsel early and identify exactly that. Hey, we never signed IP assignment agreements. Everyone's still here. Everyone's happy to sign them. Let's clean it up now. But it's sort of the housekeeping piece of the equation that you want to self-identify first with your counsel and troubleshoot. Almost all of these problems, to the extent that there are gaps, almost all of them can be fixed. It's just a matter of time and cost. And so if you can allocate those out over time before you're ready to sign a term sheet, that would be better.
Yeah, and by the way, no one ever has all of this together. Yeah. Like there's always going to be something. And that's why, it can be cleaned up usually pretty easily. And oftentimes, sometimes it's cleaned up after the financing round is done. Yeah. So for example, post-closing, maybe you have 30 days to put, privacy policies in place, or maybe, and that could be in one of the agreements we're going to talk about later.
Or get insurance policies,
right.
For example.
Yeah.
A lot of times, very early stage, you think, I don't need to pay for insurance yet. That doesn't make sense. Well, when an investor comes in, they're going to say, okay, but now you do.
Yeah, so many of these things can actually be post-funding, depending on the investor.
And then I think that the corollary question was, what about dead weight? So there's different flavors of dead weight. But if we're talking about, for example, an employee or a co-founder who's not performing, but is still presumably there and with the company, now is the time to have those hard conversations, especially before you get dilution to the cap table in the form of a new investor coming in, before you have a signed term sheet with evaluation. I'll take the co-founder example first, because if presumably the co-founder has equity, and presumably if it's all signed and documented and done correctly, which is good, but that also means you need to find a solution on how to either buy back that equity, either co-founder sale, or the company redeems it back. And if that co-founder is truly dead weight and didn't contribute to the company, so I'm giving like the most obvious example, of course, if they didn't contribute to the company to hold on to that equity, then the time to negotiate it is when the value of the common stock is still quite low, and it will go up drastically as soon as you have a new investor with deep pockets coming in. So have those conversations now. They do not get easier. They're uncomfortable for everyone. Whether you've done this one time or 5,000 times, it is always uncomfortable, but sort of getting rid of the dead weight, if you will free you up to actually build your business.
Great answers. We've got some more online and some more in the room.
There. Thank you so much for all the wisdom and knowledge you guys are sharing. I sincerely, from the bottom of my heart, appreciate this. And I have a lot of cool ideas that are still in the idea and prototype, and I'm not even at like any sort of funding stages yet, but I do have some connections to like VCs and different people that can help me get some ideas, up and running. But I have a question about the technicalities behind an NDA, because I have looked into like some stuff on like Rocket Lawyer and different websites where you can have a template of an NDA and then print it out and kind of make it legal binding. But there's been scenarios where we're trying to work with different people that had strengths in different backgrounds and talents and all different kinds of walks of life, and I kind of like, it might sound weird, is there such thing as like a verbal NDA? Is that like an actual thing? Like if I could like recorded a situation where I was like pitching a really sweet idea and we like discussed like the whole framework and like infrastructure, because it was like something around like legal tech and also like fintech, and I was wondering if like is it legal to not legal, like is there something like a legal binding NDA that's spoken and you can like record the situation, or is it always in writing?
Wish I could tell you yes, but you will never get to enforce a verbal NDA.
I
It
see.
would be lovely. It would save everyone a lot of time, but without a written document, there will be essentially no evidence that an NDA was in place.
I see. Okay. Thank you very much. Appreciate it.
Thank you. All right. If there's another question that
Great.
you'd like to do, we can do that, and then I think we should get into the term sheet, because that's probably what everybody wants to hear.
Yes, why don't you jump into the term sheet and we'll get to these
great.
afterwards.
Fantastic. Great. So let's jump right into the term sheet. We're going to do a little bit of how to talk the talk first, which is, if you've never done this before, again, this is like sort of how we want to frame this piece of it. There's something that you're going to hear, perhaps for the first time, called the NVCA. The NVCA is the National Venture Capital Association. Sounds really lame, actually very useful. The National Venture Capital Association puts out updated documents periodically, the most recent of which were actually in April of this year, so very recently. That is the core set of documents that basically everyone in the venture capital industry recognizes as market. So you're probably thinking to yourself, cool, so I don't need to pay a lawyer to negotiate anything. So it gives you the documents that are market with about 6,000 footnotes and ranges and bracketed items and things that you negotiate within the margins. So the construct of the documents themselves, yes, everybody agrees. And it consists of 5 documents: the restated certificate of incorporation, the stock purchase agreement itself, by which to buy the shares, the voting agreement, which sets forth all of the, as you might imagine, voting requirements and sort of rules and regulations of how the board votes and how the stockholders vote. The investor rights agreement that sets forth the different kinds of rights that the investors have as the new preferred investors, including information rights and registration rights. And last but not least, the right of first refusal, which is the company and the investors' rights to buy shares from the founders or other common stockholders, known as key holders in this case, if they were to want to transfer. So we'll get into the nitty-gritty of some of those in a minute, but those are the 5 documents that you might hear referred to as the charter, the SPA or the SPA, the IRA, Investor Rights Agreement, Voting agreement does not have a cool nickname. It's just the voting agreement, and which the ROFR, the right of first refusal. So when you're doing the term sheet, there is a lot that we can talk about. We could do a whole separate session on the term sheet, but the most important things that you are going to focus on are, of course, the amount of the investment, and then next to that is the valuation. The amount of the investment and the valuation will give you the picture of exactly what percentage the investor expects to own at the end of this. So what proposition they're making of, I will give you X dollars for Y% of your company. You can glean that from the valuation and the amount to be invested. And so that's, from an economic standpoint, one of the most critical things in a term sheet, of course. The liquidation preference. So the liquidation preference, and you hear that sometimes referred to as a preference stack when you have several financings, so different kinds of preferred stock. But the liquidation preference is basically last money in, first money out, right? So the last investor that comes in terms of different stages, gets their money back first in a sale event or otherwise. And so do they get their money back and stop, period, end of sentence? Do they get 1.5 times their money back before anything goes to anyone else? Do they get 2 times their money back before anything goes to anyone else? Those are things you negotiate. For the record, we're mostly seeing 1x liquidation preferences these days. There was a time where we were seeing 2x, and you see it here and there, but it's mostly 1x right now. The next important item you'll see in the term sheet that you should think really, really long and hard about is protective provisions. So again, back to the value proposition. Investor is giving you X dollars for Y percentage of your company, and along with that, since they will hold Y percentage of your company, they're going to want to have certain protections that you will not go out and do sort of a laundry list of things without either their specific approval as a stockholder or some configuration of a percentage threshold of other stockholders agreeing that they will do these big ticket items. Big ticket items that for which there might be protective provisions, whether at the stockholder or the board level, typically involve things like you might expect the next financing round. When are they getting diluted down? They would also include things like additional issuances of common stock. So an investor writes you a check for Y percentage of your company, and you turn around and issue yourself another 20% of your company. They're going to want to say in that. So those are the kinds of big ticket items that they want to protect against. There is a pretty customary set of expectations in the NVCA, but there is negotiation within the gray area of that list. So you have a place to start, and of course your counsel can walk you through each of those items, and if you need to customize them a little bit, it totally happens pretty much every time. But then the investors might also have their own sort of customized list of asks, but it's part of the negotiation process. Last but not least, of the most important things on the term sheet, and everything's important, but the next most important thing, of course, is the board composition. Depending on how much money this lead investor is putting in and what percentage of the company that they'll be purchasing with that, they most likely, not every time, but most likely will require a board seat. So at the very early stages, you might have a board of 1 or 2, and an investor might say, okay, that's great. I get the third board seat and I get a say on XYZ list of items. Again, protective provisions, big ticket items, but it is a seat on your board, and you should consider it a permanent seat on the board. Typically, even when you go to do the next round, the prior round director continues to sit there unless something crazy has happened in the meantime. You will probably continue to have that director sitting on your board, and then it just grows from there. So you grow from a board of 2 to 3, maybe to 5, and we can talk about a little bit more details if we have time in the Q&A. But you would basically just see the board grow from there, and then consider from the founder lens, as the board grows, your respective sort of voting right as a board member gets a little smaller. So, having 2 members on the board, not great because you basically always have to be unanimous. But once you go to 3 members of the board, all of a sudden, no one person can really sway the entire group without them being on board, no pun intended. So lots of dynamics to play with and consider, but board seat is usually one of the most negotiated things in a term sheet. Any questions? You're going to hate this slide, guys. You're going to hate this. I said there's so many other things to consider in a term sheet. This is the list. And this is the list of just what's in the NVCA term sheet. We don't have enough hours in the day to go through every single one of these. But, just take a look at this list. Some of these things, again, are sort of buzzwords you're going to hear if this is your first time raising a financing. If you have questions, reach out to us, find us after this. We're happy to chat with you about any of these. But, the big ones are, oh gosh, conditions to closing, that's always really big. Management and information rights. If you're having an investor that's more strategic, it's probably going to be very important to them to have certain kinds of information rights that you need to think carefully about, especially if they might be a competitor. Pro rata rights. A pro rata means the investor will have the right to maintain their percentage ownership in the future. Even if you do another fundraising round, they basically get to say, hey, let's say they bought 20% of your company in the next financing round, they get the right to keep it at 20%. They have to write a check to keep it at 20%, but they have the right to do so. So that is a really important thing to think about. Sounds great at the outset, but when you're negotiating the follow-on round, and that investor is very keen to, take the control and write the whole check, and that sounds awesome too. Oh no, now you have two investors that are going into World War III. So that's not great. So think about that really long and hard. Sometimes one other thing I'll mention that sometimes comes as a surprise, especially to first-time fundraisers, is the revesting of founder stock. So investors, when they come in, they want to know that the founders or the founding team, whatever the composition is really tied and married to the company, and that they're not going to pick up and leave tomorrow, because oftentimes they're investing in the people at this stage. So one of the ways that investors accomplish this is by having your stock as a founder either be subject to vesting if it wasn't in the first place, or revesting. So let's say you started the company 2 years ago. You owned 100% of the common stock, no co-founders, and you didn't have any vesting because it's your stock, it's your company, you own it. Nobody asked you to, so you didn't. You own 100% of the common stock. A new investor comes in, and let's say they buy up, 20% of your equity. So now you're 80-20 with the investor. They're going to say, hey, you've been doing this for 2 years. Obviously, but we believe in you. We want you to be here. We need you to sign a stock restriction agreement that says the stock you already own, and maybe it will be a portion of it. Maybe it's 50%, maybe it's 75%. But the stock that you already own, let's set back the clock on it to basically say, if you leave in a year, some of that stock goes away, becomes unvested. If you leave in 2 years, a little bit of that stock goes away. And so it vests over time, typically 4 years, but that's something you can negotiate, but good to be aware of so that it doesn't come as a shock. And it certainly, for some founders, it almost comes off as offensive if you've never heard it before. So wanted to make sure to mention that one here as well. Any questions on the term sheet before we move on? Yes. Oh, no shop. Yes, that's a really easy one, actually. So lots of complicated ones, but sometimes we have some easier ones. So no shop simply means it's in the term sheet signed between the investor and the company, and it basically says, hey, company, I, the investor, am investing time and money and advisors and consultants to basically now kick off the diligence after we sign this term sheet to get this deal done with you, whether it's in 4 weeks or 5 weeks or 6 weeks. And so I'm devoting these resources. You can't go shop this deal around to other people. So don't go find another investor and say, hey, so-and-so is giving me this valuation, but if you give me 1 million better, I'll go with you. That's what the no shop says. Usually lasts for 4, 5, 6 weeks at most. So that, listen, if the relationship isn't working and you don't want to go with that investor, as soon as that no shop or exclusivity is typically the other name we call it, as soon as that expires, you can go talk to somebody else. It's fine. But in the meantime, can't go shop.
And by the way, the investor really wants to get you signed up to that no shop, like when you're the company. And so the way that I look at it is like the company, I think, has more leverage before the term sheet is signed because the investor really wants to get that no shop in place. And so that's why I think it's important, like, sometimes you just want to get it signed and you want to get it done. But like as the company, it's really important to pay attention to these provisions because those are exactly what's going to be reflected in the actual documents. And, the term sheet is generally like very respected. And if you navigate from the term sheet, you try to, rebroker a deal when you're negotiating the documents, that's not looked upon favorably. So it is like take the time to negotiate it well, as from the founder's standpoint, because I think you have more leverage in that position.
Do these terms also applicable for individual or friends and family investors, or is it only for like VC firms?
So yes, it can be individual investors. It's more likely to be VC firms or family offices, that kind of thing. It's less likely to be this full set of term sheet with friends and family. More often with friends and family, I know this is a little off topic, but more likely with friends and family, you'll be raising on safe notes or convertible notes. And so you won't need the fully baked NVCA documents for those rounds.
And would there ever be a round where you have a mix of firms and friends
Yes,
and families?
yeah,
Oh, okay.
absolutely. Yeah, and so in that case, if it all comes down to who your lead investor is, who's writing the biggest check, and that's who you're negotiating with. If it turns out, let's say you're raising $5 million and 3 of it's coming from a lead investor and the other 2 is going to come from a couple other smaller investors, you're not negotiating with all of them. You're just negotiating with the lead investor at this stage. And the lead investor, he who writes the checks or she who writes the checks gets to set the terms. And so the lead investor in this case would negotiate the term sheet with the company. And the rest of the investors in the syndicate, as we call it, would sort of follow on those terms. They might have a few things like a side letter or ancillaries that come up, but for the most part, everybody follows the lead investor's design. Thank you. So Paige, let me ask you a question. We've set the stage, we've done the housekeeping, we've set up a data room, we cleaned up all the issues, the founders signed IP assignment agreements, everybody's happy, tie it up in a beautiful bow. We now even have a term sheet, we've signed it, everybody is ready to go. This is very exciting. So we can close next week, right?
We can try to close next week, but let's talk about what we need to do to get there. And I know we only have 5 minutes left, but on the screen you'll see kind of the main documents that need to be negotiated between company counsel and investors counsel to get to closing. Alicia mentioned a number of these, but for the group of companies founders here, I really want to focus on the stock purchase agreement. So this is the agreement through which the investor actually purchases the preferred stock. But there's a part of this agreement called the representations and warranties. And this is really important for founders to wrap their heads around. So representations and warranties are basically statements of fact about the company that the investor is going to be relying on in making their investment. And so the way I think about it is, if you were going to go buy a car, what are the things you would want to know about the car before you actually bought it? So, you'd want to know how many miles are on it. You want to know the make. You want to know the model. How many accidents has it been in? That's basically what the reps and warranties are trying to get at when it comes to your company. And so relatedly, and I'm going to skip down, there's a document called the disclosure schedules. And so those tie directly to the representations and warranties. So for example, if there's a statement in the purchase agreement that says, the company has not had any litigation for the past 5 years. Well, if that's not true, maybe, a customer has sued you.
Or a co-founder.
Yes.
A co-founder dispute of potential litigation.
Right. Then you're going to need to make a disclosure in the document called the disclosure schedules that describes why that representation is not true. And that's where the diligence and, the data room comes in from the beginning. And you'll work with your lawyers to put together these disclosure schedules. And so not only are you putting on those schedules things that, might describe why a rep isn't true, but also there's affirmative disclosure obligations in the representations and warranties. And this is just another way that the investor is going to do diligence. And so you might have a representation that says, Schedule 3.1A lists all contracts with non-solicitation clauses. And so you're going to have an affirmative disclosure obligation to list those items in the disclosure schedules. And so that's something that really ties in with the diligence and all the work you're doing in the beginning, because these are going to become part of the main transaction documents. So what time? I think we have.
Yeah, we're very
Yeah,
short
we're-
on time. So I think, listen, we can talk about common pitfalls all day long, but I think, you heard the most important pieces from us, which is get organized, be as prepared as you can, talk to experienced counsel who does this all the time, and the process will be a lot easier. And also don't shy away from learning the ropes on the details when it comes to the term sheet negotiation, especially. There's a lot there. There's a lot of content. And so, working with somebody who does it all the time will help you. But also getting insight from, if you know other founders who have raised before, that can also help you. The learning curve is steep, but it is time well spent.
Excellent. And Alicia, can you give a quick plug for your QR codes up there?
Oh, yes, of course. I mentioned very briefly in the beginning, but we have QR codes, one on each table, and there's also one, I believe, out on the registration table that looked like this. And so if you would like to schedule time to meet with us or one of our colleagues, if it's one of our IP colleagues, and actually I can give a quick shout out to a few friends who are here. We have Beth, if you would please raise your hand. Beth LaMontagne is a partner in our tech transactions group, so she does licensing, commercial agreements. If you have any questions in that universe, please see our friend Beth over here. And we also have Laura and Grace in the center here. Please raise your hands. They're also in the transactions group with Paige and I. So again, any questions about early stage company representation, financing, formations, anything like that, you can find Laura and Grace there. And of course, you can see Paige and I here. But if you'd like to talk at another time, come do the QR code, give us your email. We'll reach out to you and we'll set up a time for a complimentary consultation.
Excellent. Bravo. Thank you very much.
Thank you so much, everyone. Appreciate it.
Really a great session.